Hello, and welcome to another episode of Virtual Legality. I'm your host, Richard Hoeg, managing member of the Hoeg Law business law firm of Northville, Michigan. And I created this series, What the Trump, because I saw an administration that was animated by the Silicon Valley-esque notion of moving quickly and breaking things. And I saw it covered by a media infrastructure that was very passionate about what was being done, either for or against, but maybe wasn't as illuminating or educational or informative as I would like to see about these very important issues with respect to how the United States is run. So, what you're not likely to hear from me as part of this series on this channel are policy prescriptions, whether something that is being done is good or bad or how you should feel about it from that perspective. What you will hopefully hear from me is what happened, why it happened, and how the legal arguments work around that so that you better understand what these fights are about from a legal perspective when you're done watching these videos. With that said, before we can get into this very important, I'm going to call it a decision of the Supreme Court, even though it's really more of a non-decision, we have to go back to first principles. And in that case, the first principles are Article 1 of the United States Constitution, which says that all legislative powers herein granted in the Constitution shall be vested in a Congress of the United States. Or said another way, Congress has the sole and exclusive authority to pass laws in the United States. What kind of laws? Well, in order to understand that, we have to scroll a little bit further down in the Constitution, in which it says the Congress shall have the power to, among other things, lay and collect taxes, to pay the debts and provide for the common defense and general welfare of the United States, and to borrow money, etc., using its legislative authority. It also has the sole and exclusive authority to draw money from the Treasury and apportion that money out to whatever it sees fit. And that's an important part of our understanding of what's happening here, because what happened earlier this year in 2025 is that President Trump sought to end payments to the USAID organization and through the contracts that the USAID organization entered into through his powers as executive of the United States. But the executive has the authority to control the executive branch, but also the obligation to take care that the laws be faithfully executed. So there becomes a constitutional tension between Congress's sole authority to apportion funds to various things, to collect those taxes, to pay the debts of the United States, and the executive's authority to control certain aspects of how the executive branch actually functions. That's the baseline of this particular fight, but that's only the start of why this fight is so interesting. Now, if you've seen this reported on, since this only happened a couple of hours ago as I record this video, you might see phrases like the one espoused here by Kyle Cheney, reporter for Politico, that says the Supreme Court has upheld a lower court's order forcing USAID and state to immediately pay $2 billion owed to contractors for work they've already performed. But the use of the term upheld here, I would argue, is very controversial insofar as upheld usually refers from a legal perspective to a court looking at what was done at a lower court level or by Congress and saying, yes, that's okay, that's constitutionally acceptable, that's fine, reaching what we call the merits of a given case. That is not what happened here. In fact, if we look at the Supreme Court, again, I'm going to use the word decision here, it is a decision related to an application to vacate an order issued by the United States District Court for the District of Columbia. And if that doesn't make any sense to you, I don't blame you. We're going to have to dive deeper into the facts of what happened in this particular story to even understand that. But this was a request by the United States to vacate a decision made by a lower court. And what the Supreme Court wound up doing is saying, we're not going to do that. We're not going to vacate that lower court's decision. But it doesn't reach whether the lower court did anything right. A lot of folks will report on this, and I think as justifiable shorthand for people to understand it, as the Supreme Court essentially upholding what the lower court did. But that's not what happens from a legal perspective. The Supreme Court essentially said, no, we're not interested in doing that because, as opposed to the Trump administration and Elon Musk on Twitter moving fast and breaking things, the Supreme Court, the judiciary branch of the United States, is inherently, by its nature, a conservative institution. And I don't mean conservative as in respect of Republicans and Democrats. I mean they are very slow to move and very, very reluctant to break things, sometimes even to the detriment of their legal analysis in cases like perhaps this one and certainly others in the history of the United States. So the Supreme Court, despite what you might hear in press descriptions of them siding with President Trump or Republicans or conservatives of the big C variety in the United States, is far more animated, in my opinion, by the notion that they shouldn't be breaking things that don't have to be broken, and that the Roberts Court in particular, headed by Chief Justice Roberts, is very, very reluctant to set foot in anything that it views as a political quagmire, controversy, or question. So the Roberts Court was always going to be reluctant to say much about anything in respect of questions like the one we're discussing today, but also they are reluctant to break anything insofar as how things were working before an executive took an action like the one that Trump attempted to take with respect to cutting off funding through USAID and the contractors that it had signed up with. That all said, let's take a look at what this order actually says. On February 13th, the United States District Court for the District of Columbia entered a temporary restraining order enjoining the government from enforcing directives pausing disbursements of foreign development assistance funds. Now, that already has a lot of verbs in it, so let's break that down even further. So, the Trump administration, the government, capital G, as reported in this particular decision, tried to stop disbursements of foreign development assistance funds through USAID. That's what they tried to do. Then, the District Court of the District of Columbia entered a temporary restraining order enjoining them, preventing them from doing that. So President Trump comes into office. He says, we are not going to allow the funds that have otherwise been apportioned to USAID to be used to fund these various contracts that USAID would have entered into. And then the District Court of the District of Columbia says, no, you can't do that. That's outside your executive powers. Your job is to take care that the laws are faithfully executed. Congress has the power of the purse, and you can't do this. The present application, the Supreme Court notes, does not challenge the government's obligation to follow that order. But later on, a couple weeks later on February 25th, that same district court ordered the government to issue payments for a portion of the paused disbursements, those owed for the work already completed before the issuance of the district court's temporary restraining order by 11:59 p.m. on February 26th. Now, you might note that that's already a couple of days ago at the time of recording of this video. That's going to be a part of this decision later on. Several hours before that deadline, the government filed this application to vacate the district court's February 25th order, that's ordering payment, and requested an immediate administrative stay. The Chief Justice, that's Chief Justice Roberts, entered an administrative stay shortly before the 11:59 p.m. deadline and subsequently referred the application to the court. Now, I am not a trial litigator, and I'm certainly not a lawyer that practices before the Supreme Court. So I am not familiar with the rules of civil procedure that govern when and how a Chief Justice can issue a so-called administrative stay. But it is, as is always the case when you're looking at legal questions or other questions that you're interested in, useful to go and look at what other people have said about these various things. And so I found a law review article that summarized the position of what an administrative stay is and isn't, I think, pretty well. Unfortunately, like so many things in the law, it's not terribly illuminating in and of itself. Or as this article says, administrative stay does not have a precise definition in current doctrine, and the relationship between administrative and regular stays is not clear-cut. The Ninth Circuit, that's the West Coast in the United States, recently characterized an administrative stay as a device that is only intended to preserve the status quo until the substantive motion for a stay pending appeal can be considered on the merits, and that does not constitute in any way a decision as to the merits of the motion for stay pending appeal. So we don't have a great definition of this. Unfortunately, this is the case with a lot of law. You might think that there's a lot of bright lines, black letter law that explains how various rules and things can work. That is not always the case. This is essentially a device used by the court, in this case the Supreme Court, to say we aren't even willing to look at the merits on a preliminary basis. If you're looking for a preliminary injunction or a temporary restraining order, there are certain rules that don't necessarily reach the merits of a given case, but that we still look at, we still interpret to understand when we should issue those injunctions, those temporary restraining orders. An administrative stay is even before that, even a lesser level of review. We think that we need even more time to come to that level of understanding, and so this is essentially just a pause. This is a pause that the Supreme Court put in place a few days ago to say we need to look at this a little bit further, and now this decision right now that we're reading as part of this video is that decision that they came to after thinking about it a little bit more. Or as I said earlier, more of a non-decision. The application for that vacation of the lower court's decision is denied, given that the deadline in the challenged order has now passed. That's the earlier date we talked about. And in light of the ongoing preliminary injunction proceedings, there's a lot more going on with this particular case, the district court should clarify what obligations the government must fulfill to ensure compliance with the temporary restraining order with due regard for the feasibility of any compliance timelines. So, the district court says you have to pay this money out on contracts that are already effectively finished, that work was already done on before I entered my original order. The government said, no, we shouldn't have to do that. You don't have the power or authority to make us pay things. And now the Supreme Court says we're not going to give you a vacation of that earlier order, government. And so you are going to wind up having to pay things, but the timeline doesn't make any sense now because this process took a few days. And so the district court has to come up with a new timeline that you can abide by regarding the feasibility of any compliance timelines. So that's the state of play right now. I know it's very confusing when you have lower district court judgments, when you have appeals processes, when you have injunctions and temporary restraining orders happening at the same time. But that's what this comes down to. And then we have a dissent. That's the order on the first page. That's what the Supreme Court has decided. It's not otherwise signed by anybody. It's just by the majority of the Supreme Court. Then we have a dissent from Justice Alito, Justice Thomas, Justice Gorsuch, and Justice Kavanaugh, who are all Republican appointees of the Supreme Court, that says, does a single district court judge who likely lacks jurisdiction have the unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? Well, that really answers the question for you just in the way that it's phrased. The answer to that question should be an emphatic no, says Justice Alito, but a majority of this court apparently thinks otherwise. I am stunned. And it was actually this paragraph that drew my attention to wanting to discuss this with you here in Virtual Legality, which is to say you don't usually hear the Supreme Court justices be this animated, this kind of divisive in the context of an opinion, in the context of legal rhetoric. You do hear them take small snipes at each other, usually through footnotes and other attributes like that, but I am stunned is a lot of harsh language when it comes to a Supreme Court decision. Now, what does Justice Alito say happened here? In capsule form, this is what happened. Respondents are a group of American businesses and nonprofits that receive foreign assistance funds from the State Department and the U.S. Agency for International Development, that's USAID. They brought suit and claimed that the current administration's temporary pause of foreign assistance payments is unlawful. On February 13th, 2025, the district court issued a temporary restraining order requiring the government to halt its funding pause. It based that decision on a finding that respondents are likely to succeed in showing that the government violated the Administrative Procedure Act, or APA. Now, that in and of itself is an interesting piece of the puzzle here because the Administrative Procedure Act is a law that requires the executive branch agencies in government to do things in various ways. But there is an open and continuing question as to whether or not the Administrative Procedure Act and various other aspects of the independent agency creation framework that has governed the administrative state in the United States is constitutional in and of itself. We talked about that in our earlier episode in What the Trump, talking about the fact that Trump issued an executive order to try to take control of those independent agencies and suggesting that Congress was not constitutionally authorized to have those agencies be as independent as they were claimed to be. This is another area in which that is a particular bit of softness for Congress. And though Justice Alito isn't acknowledging it here, it is worth noting that if Congress doesn't have the authority to provide for the executive branch to abide by certain rules like those in the Administrative Procedure Act, then that in and of itself would be an unconstitutional exertion of power, and the Supreme Court is ultimately going to have to decide that at some point during this administration. After issuing the TRO, the district judge grew frustrated with the pace at which funds were being dispersed, and I highlighted grew frustrated there because that is a bit of editorializing from Justice Alito. And on February 25th, he issued a second order requiring the government to pay out approximately $2 billion US. The judge brushed aside the government's argument that sovereign immunity barred this enforcement order. We'll talk about sovereign immunity in just a minute. And he took two steps that, unless corrected, would prevent any higher court from reviewing and possibly stopping the payments. First, he labeled the order as a non-appealable TRO, temporary restraining order. And second, he demanded that the money be paid within 36 hours. Now, the TRO aspect of this is interesting because a temporary restraining order is the level below a preliminary injunction. An administrative stay is the level below a temporary restraining order, but a temporary restraining order is usually designed to keep the status quo as it is. right? That you are restraining somebody from doing something that would change things before a court can look at it and determine that that change would be illegal or otherwise harmful. In this particular case, as you can already see just from how this is described, this restraint, what the temporary restraining order is doing, is restraining you from not doing something. If you're the U.S. government, it is restraining you from not paying out the amounts that are owed on these contracts. So it's a little bit of an unusual application of the concept of a TRO as it stands. We'll see Justice Alito harp on that a lot more as we go through this document. Then the government moved for a stay pending appeal in the district court. The government quickly filed an appeal in the United States Court of Appeals for the District of Columbia, but with only 4 hours to spare before the payment deadline, the D.C. Circuit dismissed the government's appeal because it took the district court's TRO label at face value and determined it lacked appellate jurisdiction. With nowhere else to turn and the deadline fast approaching, the government asked this court to intervene. At the last moment, the Chief Justice issued an administrative stay. You'll see references to the fact that Justice Roberts only posted that administrative stay in the last couple of minutes before the deadline in a couple of places in this document. This, I think, is best read as Justice Alito being effectively legally furious at how the court has operated on this question. You don't have to agree with Justice Alito. I think a lot of this language is maybe a bit superfluous and is evidencing a certain amount of animosity in the way the court operates that is probably not useful for a belief in the Supreme Court as deciding body in the future, but reasonable minds can differ on even that. Nevertheless, at the last moment is unnecessary to make this sentence work and is designed to suggest that Chief Justice Roberts was reluctant to act on this at all. Unfortunately, a majority has now undone even that stay. As a result, the government must apparently pay the $2 billion post-haste, not because the law requires it, but simply because a district judge so ordered. As the nation's highest court, we have a duty to ensure that the power entrusted to federal judges by the Constitution is not abused. In fact, the Supreme Court, like the president, is the highest power within their branch, the judiciary versus the executive, and so they do have a responsibility to make sure that judges are doing what they are supposed to be doing. Today, the court fails to carry out that responsibility. So Justice Alito is pissed. That is self-evident from this document. It will continue to be self-evident as we go through it. To start, it is clear that the district court's enforcement order should be construed as an appealable preliminary injunction, not a mere TRO. A TRO, as its name suggests, is temporary, and its proper role is to restrain challenged conduct for a short time while the court considers whether more lasting relief is warranted. The order here, while commanded the payment of a vast sum that in all likelihood can never be fully recovered, is in no sense temporary, nor did the order merely restrain the government's challenged action in order to preserve the status quo. Rather, it acts as a mandatory injunction requiring affirmative action by the government. And if we were to rank the ways in which courts think about these things, an injunction that requires you to do something, again, that kind of restraint on not doing something, is the most difficult, highest threshold of proof that you are supposed to have before a court requires you to do it. Because the legal system, and we've talked about this in Virtual Legality before, is pretty bad at making sure that people do things. It's okay at making sure that people don't do things, and it is best at moving money around. And that is what's happening here, is that money is being moved around, but under the auspices of an injunction or temporary restraining order, which, again, we'll see Justice Alito object to. Given its likely irreversibility, the district court's enforcement order effectively gave respondents a portion of the ultimate relief they seek. They sued to get their money. They're getting a portion of that money. For these reasons, the Court of Appeals had jurisdiction to consider the government's appeal, and we have jurisdiction to review and summarily vacate that court's erroneous judgment. And this is important because, again, despite what you might see in other articles or other reporting on this matter, the Supreme Court did not reach the merits of what the district court did. And so this appears to be a response from Justice Alito to what was likely a position held by Roberts and the majority in this particular case, that they didn't have jurisdiction to hear the vacation request in any event because this TRO was, quote unquote, non-appealable. So we know Justice Roberts from history likes to avoid political questions for any reason and finds a hook to hang his hat on, from jurisdictional requirements to standing requirements and various other reasons that bother me personally as a lawyer that would like to see the law cleared up on these questions, but that he feels is important to help keep the Supreme Court separate from the other branches and to keep their authority and understanding in the United States all along. So when we talk about these things, I have a relatively strong disagreement with how Roberts conducts operations at the Supreme Court as it stands. But that doesn't mean that even if they found jurisdiction here, the other members of the court would have agreed with Alito on his analysis, which is to follow. Even if the majority is unwilling to vacate the district court's order, Justice Alito says, it should at least stay the district court's enforcement order until the government is able to petition for a writ of certiorari. In considering whether to issue such a stay, we ask, at a minimum, 1, whether the moving party is likely to prevail on the merits, and 2, whether that moving party is likely to suffer irreparable harm. Said another way, when we look at these things, we are going to look overall at whether the party that's asking us to do something is likely to win when we get to the whole case, and then 2, whether or not that party that's asking us to do something would be so harmed by our failure to act that we can't fix it after the fact. So when you're asking us to do something early before we've heard the whole case, those are the 2 factors that we look at. In close cases, Justice Alito says, we also take into account other equitable considerations. So on the likelihood of success, Justice Alito says the government has shown a likelihood of success on the merits of its argument that sovereign immunity deprived the district court of jurisdiction to enter its enforcement order. Sovereign immunity bars a suit by private parties seeking to impose a liability which must be paid from public funds in the Treasury. And yes, if you didn't know this already, sovereign immunity basically protects all of the various governments in the United States, whether that's the federal, the state, or their local government, from being sued by private citizens, even for things that are done badly by them, as a function of the fact that the court system that you'd be suing them under is also a part of the sovereign. That you can't sue the sovereign that runs the courts through the courts. And yes, if that strikes you as immensely unfair and results in a lot of injustice done by these various governments, there's a long history of that. And there are attempts by Congress and other local bodies to let you sue the various governments for things like civil rights violations because those injustices were so strong. But, says Justice Alito, this is exactly what the district court ordered here. Or as they say, the restrained defendants shall pay all invoices and letter of credit drawdown requests on all contracts for work completed prior to the entry of the court's TRO on February 13th. Sovereign immunity may be waived, Justice Alito notes, but to sustain a claim that the government is liable for awards of monetary damages, the waiver of sovereign immunity must extend unambiguously to such monetary claims. So like I said, Congress has passed laws that allow you to sue for things like civil rights violations, and they do it expressly in black letter law within that law that says you can go and get money from the government for a violation of this type. Attempting to satisfy this strict requirement, respondents point to the APA's waiver of sovereign immunity for certain actions, seeking relief other than money damages. That language, as we have explained, distinguishes between specific relief, that's relief that requires somebody to do something, which is permitted under the APA, and compensatory or substitute relief, that's monetary relief, which is not. But the relief here more closely resembles a compensatory money judgment rather than an order for specific relief that might have been available in equity. So one of the things that's noteworthy here from a legal perspective is that what this temporary restraining order that was issued by the lower court sought to do was not so much say that you owe X amount of dollars one way or the other, but to mandate that you do something, to mandate that as the government, you pay your contracts, you pay your drawdown requests, you do these various things, and then claim that that falls outside of sovereign immunity because it's an order to do something specifically, not an obligation from a monetary perspective. It's a little bit of legal wrangling, a little bit of plate spinning from the court that Justice Alito, I think, has a strong argument here against to say that that isn't what we're talking about as specific relief. That is essentially just monetary relief that you have described in a different way. Or as he quotes from this other precedent, an injunction to compel the payment of money past due under a contract or specific performance of a past due monetary obligation was not typically available in equity under the powers of a court to order somebody to do something or refrain from doing something. Hoping to escape this conclusion, respondents point to a case called Bowen. In that case, we held that the APA's waiver of sovereign immunity covered a district court's judgment, reversing a final order of the Secretary of Health and Human Services refusing to reimburse Massachusetts for certain Medicaid expenditures. Unlike the district court's order here, that judgment did not purport to order that any payment be made by the United States. Indeed, we have since clarified that Bowen has no bearing on the unavailability of an injunction to enforce a contractual obligation to pay past money due, the sort of relief that appears to have been ordered here. The district court, however, failed to mention, much less reckon with, Bowen or Knutson before plowing ahead with its $2 billion order. Again, plowing ahead is a little bit of editorializing from Justice Alito. Nor did it take account of our previous suggestion that the proper remedy for an agency's recalcitrant failure to pay out may be to seek specific sums already calculated and past due in the Court of Federal Claims, that you can in fact sue under a different law passed by Congress for a breach of contract. You did something, you did work for them, they didn't pay you. That's different than being ordered to pay in this particular context under the law. Finally, the government has a strong argument that the district court's order violates the principle that a federal court may not issue an equitable remedy that is more burdensome to the defendant than necessary to redress the plaintiff's injuries. In this case, the district court's enforcement order functions as a universal injunction defying these foundational limits on equitable jurisdiction. Now, what does he mean by any of this? The district court ordered the government to pay all invoices and letter of credit drawdown requests on all contracts for pre-TRO work. That order encompasses more than just respondents, more than the people suing. And the district court offered no reason why universal relief to non-parties is appropriate here. And this is not the sort of case in which only universal relief is feasible. Nobody has suggested that the government is unable to identify respondents' allegedly owed funds and pay out only to them. Limiting the scope of relief in that manner would be significant. Below, the government represented respondents seek roughly $250 million US. Still a large figure, but a fraction of the $2 billion ordered. So what he's saying here is that the Supreme Court and all courts in the United States Constitution are only allowed to opine, only allowed to do things with respect to cases or controversies before them, which means that they are only supposed to provide relief, redress, however you want to frame it from a legal perspective, to the parties in front of them. This was instead a kind of universal requirement to pay out everything that happened before the TRO was issued, and that's going to naturally encompass people that are not before the court. So I think this is a stronger argument from Justice Alito than some of the others that we have already seen. There are problems with what Justice Alito has already offered. But again, the Supreme Court did not agree with any of this. This is a dissent. This is not the order of the Supreme Court. And so Justice Alito is on the wrong side of this particular opinion. The government has shown that it is likely to suffer irreparable harm if the district court's order is not stayed. Now here, I want to point out that I think this is effectively wrong. The government has represented that it would probably be unable to recover much of the money after it is paid because it would be quickly spent by the recipients or dispersed to third parties. Respondents did not credibly dispute this representation, and the district court did not find that it is incorrect. So the notion here, again, is that we should put our own stay in place. We should prevent the district court from requiring these payments if the government is likely to succeed on the merits of their argument, and they would be irreparably harmed if we didn't do this. And this is the part where he's trying to establish that there is irreparable harm. The problem he has is that because he's already stated that this is more of a monetary compensation issue than a specific performance one, it's very difficult to find irreparable harm. Why? Because irreparable harm, as summarized here by the Cornell Law School, is a legal term that refers to harm or injury that cannot be adequately compensated or remedied by any monetary award or damages that may be awarded later. So, Justice Alito here steals a base. It's clear that if the government pays out X amount of dollars, then it would be easy enough to redress that particular harm to them by paying them back that amount of money, perhaps with interest, however you would want to see that, if the government ultimately wins the day. Instead, Justice Alito says, well, that money's going to be spent, it's going to be gone, and so the money might not ever make it back into the government's treasury, and so that's irreparable harm. But that's not how money works. The law sees money as fungible. It doesn't mean that you have to have the $100 that was paid to you to give back. You can spend that, and as long as you can get that $100 from a different source and pay the government back, then the government is going to seek that redress. It also isn't the case that these entities in and of themselves have to be the ones that pay them back with only their current operating funds, right? They can go get a loan. There are any number of ways that money could be acquired here that could pay the government back. Now, it does seem unlikely that these various parties can collect $2 billion. It would be very difficult to do. But when we talk about irreparable harm under the law, we almost always aren't talking about monetary payments, because monetary payments are the thing that we think that the law can fix the easiest. We usually balance the equities and weigh the relative harms in close cases, says Justice Alito. For the reasons I've explained, this is not such a case. I don't see this as close at all, and our analysis could end there. Nevertheless, respondents' equitable arguments are insufficient anyway. They contend that the failure to pay the money in question would cause them irreparable harm. That's why they get this order at the lower court level. because without those funds, they could not continue to operate or would have to reduce the work they do. As a result, they claim, recipients of their services would suffer. These potential consequences are, of course, serious, but any harm resulting from the failure to pay amounts that the law requires would have been diminished, if not eliminated, if the Court of Appeals had promptly decided the merits of the government's appeal, which it should not have dismissed. That's fine, but it's the ifs and buts were candy and nuts kind of notion of legal reasoning. They could still be harmed here, regardless of what the Court of Appeals should have done, Justice Alito. This is by far the weakest section of his argument, and I think it suffers from major issues there. If it decided in favor of respondents, the government would be obligated to pay all the money that is due, and respondents would have suffered only a short delay in the receipt of payments. And how that argument doesn't also apply to the government is unclear. And if the government prevailed on its sovereign immunity argument, which he thinks is a sure winner, neither respondents nor any of the recipients of their services would have suffered any unlawful consequences because they weren't owed any of this money anyway. In sum, the factors we consider in deciding whether to issue a stay weigh strongly in favor of granting that relief. Today, the court makes a most unfortunate misstep that rewards an act of judicial hubris and imposes a $2 billion penalty on American taxpayers. The district court has made plain its frustration with the government, and respondents raise serious concerns about non-payment for completed work. A federal court has many tools to address a party's supposed nonfeasance. Self-aggrandizement of its jurisdiction is not one of them. I would chart a different path that the court does today, so I must respectfully dissent. So overall, I think Justice Alito has a tenable position to say that the district court overreached in its universal application of these rules, and that the Supreme Court should be more concerned about district courts and how they operate than it seems to be right now. But the overall argument that he makes for why this should be vacated, why the merits would be won by the government on this particular question, I think are fairly weak. So looking at this holistically, I see a decision or non-decision by the Supreme Court that is effectively one that says, we don't like the way the district court operated, or at least from the dissent's point of view, and so they shouldn't be allowed to operate that way. And they have some reasons for why that shouldn't be the way that the court system operates. But the actual argument for why the court should have vacated the lower court's decision is the weakest part of this conversation. Also, I don't think, because the Supreme Court didn't otherwise speak on this matter, that the Supreme Court has one position or another on the merits of the underlying district court's order. I think it's more likely that Justice Roberts and Justice Barrett and the others that are forming the majority of this decision looked at this and said, well, this is a political question. This is a thorny bush for us to enter into. It's not at all obvious that we have the right of it if we did enter into it. And it's easy enough for us to say, well, it's not appealable. We shouldn't be looking at this anyway. We are going to abdicate our responsibilities on this particular question. And I think that's what Justice Alito is responding to more than anything. He's been on this court for a long time. He's seen Justice Roberts operate the court in the way that he does. And at the end of the day, I think this anger, the animosity that you can read between the lines of this particular decision is Justice Alito getting sick of Justice Roberts kicking these important decisions down the road to where they are potentially more harmful to more parties. And this is a reaction to that. What it isn't is the Supreme Court upholding the lower court's decision. And it also isn't a constitutional crisis. So you'll also see reporting a lot during this administration about what represents a constitutional crisis or not. I want to use a definition here so that we can talk about it a little bit more fulsomely. In political science, as described by Wikipedia, which I don't recommend for any political questions whatsoever, a constitutional crisis is a problem or conflict in the function of a government unit that the political constitution or other fundamental governing law is perceived to be unable to resolve. So, we have all these rules and ways that the Constitution of the United States works. You see me continue to refer to them here in Virtual Legality. The argument here is that what is happening is something that the Constitution doesn't otherwise have an answer for, doesn't have an understanding for. And constitutional crisis at its most baseline level might be when the president refuses to agree to a Supreme Court decision, refuses to perhaps pay out this $2 billion, and then Congress refuses to impeach. But even including that Congress refuses to impeach part explains why this is not, at this present moment in time, a constitutional crisis of any fundamental level. Because even if President Trump and his administration, or Elon Musk, or whoever you want to blame for these various things, were to refuse the district court's order to make these payments on the timeline that is set forth whenever that decision is made, Congress still has the opportunity to impeach the president for failure to faithfully execute the laws. And just because Congress doesn't do that, if they don't do it, in fact, doesn't mean that democracy or the notion of the Constitution has failed. That's one of those areas where I really get more interested in how people are talking about these things, because I think too many of our leaders, too many of our politicians look at questions of, I don't like the way this policy went, I don't like the way the government did this thing or didn't do this thing, and that's a failure in democracy. To the extent that impeachment requires the representatives of the people to actually take an act against another elected official like the president, that is democracy in action. And if you didn't get the result that you wanted, that doesn't make it undemocratic. That simply makes it a result that the other representatives, the majority of representatives, didn't agree with you on. And I understand how that can feel like it sucks. I haven't had a single government in my lifetime, I think, that I agree with even the majority of the actions that they have taken. And yet, that doesn't mean that democracy has died. So when Elon Musk posts things like, what is the point of having democratic elections if unelected activist judges can override the clear will of the people? It's important to remember that those judges are put in their positions through the democratic process, that there are appointments made at the Supreme Court level. The Supreme Court makes certain decisions on how the district courts are to operate. And just because you disagree with them doesn't mean that democracy has failed or is at risk of failing or that we're in the midst of a constitutional crisis. Or as I said to Mr. Musk on Twitter, in short, the will of the people is set forth in our Constitution, which itself provides for the appointment of judges, and this is important now, the limited powers of our government. So I'm sure I didn't win any friends with a lot of the posters on Twitter with respect to this question, but Elon Musk does this a lot, and I want to point out that just because something isn't going the way that you want it to, if you're a United States citizen, it doesn't mean that democracy has failed. Or said another way, this stuff is complicated. And only a few days ago on the National Constitution Center website, and I didn't look at the politics here, I just looked at this article, which I thought was relatively neutral. They asked, can a president refuse to spend funds approved by Congress, and came up with all sorts of analysis. The process in which the president withholds or delays spending on programs authorized by Congress is called impoundment. This practice dates back to the third president, Thomas Jefferson, and it has at times been controversial because the impoundment of funds can put the executive and legislative branches in conflict. There is tension there, right? When you learned about checks and balances in grade school, it didn't mean that there was never tension between the branches. That's the design of the U.S. government. So there's tension, but that doesn't itself make a crisis. As we already talked about, Article 1, Section 8 and Section 9 talk about how Congress is supposed to be able to account for debts and apportion things to what it wants to apportion, but that's in tension with the take care clause of the executive's requirement to take care that the laws are faithfully executed. The most noted example of a conflict over impoundment took place in the 1970s. This is going to sound familiar to you, when President Richard Nixon refused to spend funds on numerous programs approved by Congress. During public hearings on the matter in 1973, Nixon's critics said the president was using his impoundment powers to effectively veto programs by cutting off their funds. President Nixon's supporters believed that Nixon was managing funds in an inflationary environment using his take care powers. They argued that essentially take care that the laws are faithfully executed required him to make sure that money wasn't being wasted. The president's obligation to faithfully execute the laws plainly includes, says this attorney general, an obligation to prevent waste. Impounding to save the taxpayer's dollar has always had the full support of Congress. Congress passed the Congressional Budget and Impoundment Control Act of 1974 in response to the controversy. So Congress, as we've noted above, said, we are going to pass a law that requires the executive to do things in various ways, just like the APA, just like the other things that we've talked about already in Virtual Legality. This is an open question in the present political context because we don't quite know the bounds of what Congress can require of the executive branch. Title 10 in this act in 1974 is commonly referred to as the Impoundment Control Act, and it requires the president to report to Congress when he impounds funds as a deferment, a temporary delay, or a rescission, a permanent cancellation of spending. The Supreme Court considered the impoundment question in 1975 after the ICA was passed. The city, New York, sued after it did not receive funds allocated to it under the Federal Water Pollution Control Act amendments. President Nixon had vetoed the bill, but Congress overrode the veto. Nixon then reduced program spending. In his unanimous opinion, Justice Byron Wright wrote that the sole issue before us is whether the 1972 Act permits the administrator to allot to the states less than the entire amounts authorized to be appropriated. We hold that the Act does not permit such action and affirm the Court of Appeals. That Congress wins this round because they have the power of the purse and that the executive cannot just withhold funds, which is what is at issue here. Another effort to give the president more flexibility in controlling how funds allocated by Congress are spent was the Line Item Veto Act of 1996. The act amended the ICA to authorize the president to cancel in whole any dollar amount of discretionary budget authority, any item of new direct spending, or any limited tax benefits signed into law. You might remember this if you were around in the 1990s, but Bill Clinton used the line item veto 82 times during its brief existence, spoiler alert, with Congress restoring 39 appropriations. In Clinton versus the City of New York, the Supreme Court struck down the line item veto in a 6-3 decision. Justice John Paul Stevens said that under the Constitution's presentment clause in Article 1, Section 7, the president must approve or reject a bill as presented to him by Congress in its entirety. He can't amend things, he can't revise things. Line item vetoes do that, and so he doesn't have that authority, and it was rejected as unconstitutional. There is no provision in the Constitution that authorizes the president to enact, amend, or repeal statutes, he concluded. Justice Stephen Breyer, joined by Justices Sandra Day O'Connor and Antonin Scalia, believed the Line Item Veto Act was constitutional. Again, not a constitutional crisis. These are just legal minds thinking through how the bounds of congressional and executive authority, when they clash, might otherwise be fixed. The act represents a legislative effort to provide the president with the power to give effect to some, but not all, of the expenditure and revenue diminishing provisions contained in a single massive appropriations bill. And this objective is constitutionally proper, said the dissent. Right? That's not the law of the land, that's the dissent. In recent years, the first Trump administration and the Biden administration faced questions when spending on certain programs was paused, including delays related to spending in the Ukraine and on the border wall. Today, as the OMB continues to review federal spending programs, more questions about the roles of Congress and the president in the spending process are likely to occur. Indeed. And they're likely to continue to occur throughout this administration, which, as I said, is animated by the notion of moving quickly and breaking things, and the Supreme Court is very much animated by the opposite notion. So when it is pressed for things like administrative stays on very tight timelines and making decisions on even tighter timelines, it is unlikely that you are going to see the Supreme Court side with the moving fast and breaking things contingent, whether that's bearing a Republican or Democratic coloration scheme. That's my opinion. You don't have to agree with it, but I think that's what you're more likely to see, and I think that is what you see with the Supreme Court acting in the way that it does in Department of State versus AIDS Vaccine Advocacy Coalition. So, that's been Virtual Legality for today. I hope it was informative and informational. If you like content like this, please consider supporting the channel at Patreon on the links provided in the description, by having memberships to the channel, by putting forth super chats during live streams, or if none of that appeals to you, just subscribing, liking, disliking, whatever floats your boat in terms of clicking on Google's various buttons and telling your friends that we are having these conversations. Last but not least, leave comments to these videos or comments to the podcast versions of these videos. Let me know what you think. I try to respond to as many as I can, as quickly as I can. What do you think of this decision? What do you think of the acts of President Trump? What do you think of the acts of the district court operating here? What do you think of the acts of John Roberts in the Supreme Court? There's lots of layers to untangle here with respect to all of these various legal questions. And do you think there's a constitutional crisis here or pending on any or all of this? Thank you so much for joining me in Virtual Legality, and I look forward to seeing you in the next one.
Virtual Legality is a YouTube video series with audio podcast versions presented as commentary and for education and entertainment purposes only. It does not constitute legal advice and does not create an attorney-client relationship. If you have legal questions about the topics discussed, please consult your own legal counsel.